All right, good morning. What is your name?
Good morning, Brady Fisher.
Okay, so Mr. Vogler, this is People v. Brandy Fisher, file 21-93 or 93178FH. Here for a docket call, and also we have a motion to reinstate bond and amend the conditions. In terms of the docket call, do you know what our status here is of the case?
Yes, I do, Your Honor. There's another case right now pending in the district court. There's been a plea offer made to us that basically wraps this case into that case.
Okay.
So we're not really ready to proceed here.
So you want me to continue the docket call to the January 5 docket?
Yes.
January 5 at 9:40 a.m. And as to your motion with bond, go ahead.
Judge, I don't have a whole lot more to add other than, as I mentioned, there is a case in the district court. That is a felony case also. Her bond set in that case is $10,000, 10%. I think the most important thing, I recognize she was gone for a number of years here, but my client did turn herself in on court bench warrant, came up here with the aid of her sister, turned herself in. She is involved in the family court in Macomb County. She has an attorney there, Susan Dunn. And in that particular case, it appears like the Department of Health and Human Services would like to place, in fact, they would like to place the children with her. But I think the fact that this bench warrant was outstanding in this case was preventing that. So she executed a delegation of parental authority. The children are placed, I believe, with a relative, if I recall that correctly. She has a residence in Detroit where she's been residing this time. During the past 4 years, there's been a number of times where she has turned herself in downstate. Not good. One of the things too, I think is important is the fact that back in September of 2021, she completed a 6-week anger management course and has engaged in rather extensive counseling in Centerline, Michigan. And I think that at least goes to it speaks towards the allegations in this case.
Okay. Thank you, Mr. Vogler. Mr. Wargo, People's response?
Your Honor, I would note that defendant will be facing, as part of our offer, there's potentially not doing an absconding charge that would be forthcoming. If we're unable to resolve, I would be seeking remands to file felonious assault and child abuse second charges. Your Honor, this is a very serious case, and as to the allegations, Ms. Fisher is waiting in the wings for the kids. I'm pretty certain that once the department becomes aware of the specifics of the allegations in this underlying case, that's just not going to be an option. Nothing else, Your Honor.
So you're opposed to amending the bond conditions to remove the no contact? Am I hearing that right?
Yes, we'd be opposed to removing those conditions as well as any reduction in bond, Your Honor. She's facing a lot here.
Well, I mean, what I have in front of me is 2 counts of a 2-year felony. The defendant had posted a $10,000 10% bond back in 2021, and then didn't appear. And the warrant was issued. She did turn herself in on it now, 4 years later, so I revoked her bond pending this hearing. There's another felony pending in the district court, but it sounds like from both the people and the defense that there's a possible global resolution of the whole case. And I think looking at all of the factors of 6.106F, I mean, I think it might be appropriate to set a bond rather than leave bond entirely revoked here. I would note that a $10,000 10% bond was insufficient to secure Ms. Fisher's appearance before. So a personal bond would certainly be insufficient to secure her appearance. The court will set a $50,000 cash or surety bond with the same conditions. And at this point, Mr. Vogler, I'm not going to amend or remove the conditions. I just don't know enough about the underlying facts here. And I don't know whether the department downstate that wants to place the children with her is aware of these facts. I mean, if it may be that removing those conditions is going to be entirely appropriate, but I can't be confident of that today. So I'm not going to remove those conditions, but I will set a bond. And then we'll be next January 5th at 9:40 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Okay. All right. We'll see you then, Ms. Fisher. If you do post the bond, you have to be in person in court on January 5th at 9:40 in the morning.
Thank you.
All right. Is this Mr. Chapman?
It is, Your Honor.
All right. This is People v. Wyatt Chapman, file 25-93379FH. Counsel, you want to state your appearances, beginning with People?
Morning, Your Honor. Zachary McClendon on behalf of the people.
Hey, good morning, Your Honor. James Gilbert here on behalf of Mr. Chapman.
All right. Good morning. We're here for an arraignment. Have you had a chance to review the charging document with your client?
We have, and we will waive the reading.
Okay. And how does he wish to plead to its charge?
He'll stand mute at this time, and we are not requesting a forensic.
All right. So I will enter a plea of not guilty on Mr. Chapman's behalf. What would be the estimated length of trial?
Probably 2 days.
I agree, Your Honor.
All right, appropriate for docket call on January 5th at 9:50 a.m.
Believe it's appropriate.
All right, anything further from the defense?
Your Honor, we would request that the court would consider at this time, Mr. Chapman has gotten all his other matters in different counties resolved, that the court would possibly consider a bond reduction at this time. He does have extensive family in the area. And like I said, the items that are here are his sole focus at this point.
Hey, Mr. McLennan, I guess right now, just to confirm, the bond is set at 50,000 cash or surety. Is that right?
That is correct.
Okay, Mr. McLennan, people's position.
The people would oppose a reduction in bond, Your Honor. He's a habitual floor offender. He's facing a 15-year felony. People obviously believe there's strong evidence to support a conviction in this matter, so we would oppose a change in bond.
I mean, I don't know anything about the facts of this case, but just looking at the charge itself, I'm not sure that there's an immediate threat to public safety. The bond is set pretty high under those circumstances. I do think maybe that was influenced if he had other matters pending in other counties and those taken care of. He does have okay, well, the priors are just a couple possessions and a maintaining. So his priors are not terribly troubling, even though the possession of methamphetamine is technically a high severity felony. It's not, it's a possession charge. Is there any failure to appear concerns for Mr. Chapman presently or in the past? Okay, I'm going to amend bond to a $10,000 personal recognizance bond with the
Thank you very
same
much.
conditions if there were any conditions.
Thank you, Mayor.
All right, we'll see you January 5th at 9:50 in the morning, Mr. Chapman.